Okay, and I'm gonna mute that, and I am gonna share. And I learned how to cut already. I'm cutting a lot of people out, so that's good. That's good. Yeah, I learned how to cut the thing. Okay, there you go. Go ahead, B.
Okay. Should the court grant the motion? So, do you want me to go ahead into the answers or read the sentence before?
Up to you. You the boss.
Okay, I'm going to read the sentence before. At the woman's trial, after the government introduced the above evidence, at the woman's trial, after the government introduced the above evidence and rested its case, her lawyer moved for a motion for her lawyer moved for a judgment of acquittal on grounds of insufficient evidence. Motion moved for judgment of acquittal on grounds of insufficient evidence. I don't think I've ever heard of a motion of acquittal, judgment of acquittal, but A, no, because the evidence shows that both the woman and her sister agreed to import cocaine. That an agreement. Evidence shows that both the woman and the sister agreed to import cocaine.
Again, it's not as easy as I thought. Baby bird, you hitting problems. Go ahead.
Because I don't know much about the facts to strike if they agree.
Okay. All right.
B, no, because the evidence shows that both the woman and the sister possessed cocaine. So here it's possessed. C, yes, because the evidence shows only that the woman and sister committed separate crimes of cocaine possession. Shows only that the woman and the sister. I don't really like the only part. I'm going to strike C. I can undo it later. D, yes, because the evidence shows that the woman effectively withdrew from the conspiracy when she cooperated by giving a statement. Effectively withdrew from a conspiracy. That makes me feel like it's a little more like a criminal question. I don't know. I'm not going to strike D either. Yes, because the evidence shows the woman effectively withdrew from the conspiracy when she cooperated by giving a statement. I'm just going to strike C. Those are all... Maybe D. Okay. I don't know enough. I'm going to leave it. Just
Okay.
one.
So read the fact.
I'm going to read the facts. A woman and her sister took a trip to the Caribbean. When they passed through U.S. Customs inspection, upon their return, the customs officer found liquid cocaine in several bottles each of them was carrying. They were arrested. Upon separate questioning by custom officers, the woman broke down and cried, "I told my sister that there were too many officers at the airport." The sister did not give a statement. The woman and her sister were indicted for conspiracy to import cocaine. They were tried separately. Okay. At the woman's trial, after the government introduced the above evidence and rested its case, her lawyer moved for a judgment of acquittal on grounds of insufficient evidence. Should the court grant the motion? And I'm going to say no, so I'm going to go ahead and strike out C. A, no, because the evidence shows that both the woman and her sister agreed to import cocaine. B, no, because the evidence shows that both the woman and her sister possessed cocaine. What doesn't matter if you possess it. I'm going to pick A because they agreed.
Okay. One thing that I want you guys to know is you have to do something about crime. So one thing that B did is pretty good, but she totally forgot about the crime. Whatever the crime is on the fact pattern, it's gonna be like honeys, like bees to honey, like lights. There's the movie called Bugs, and there's lights outside and on the porch, and that light is to zap all the bugs, right? So it won't bite you or won't come into the house. So in the movie, one bug go, oh my God, I'm going, zzz, he died. And then the other one saw what happened, but he's still going toward it, right? Stop, right? The third one saw the second one die, but he still go, So it's so strong that take over their thinking, that even though they saw bugs that all die in front of them, and they still doing it. And that's how strong they are attracted to lights. We as lawyers, we are attracted to crimes. They gave you a crimes here, it's called conspiracy. So you should have circled the conspiracy and kind of pause it and think how they test you on it. Okay, so there's two parts. There's part called crime, which is criminal law, and there's the other part is criminal procedure. Remember the 4th, the 5th, the 6th, the 7th, the 8th amendments. So I would hopefully that B were talking about, oh, it's conspiracy. So she fly through it. Okay, she had to. So here the lesson today is you have to you are attracted to crimes, words of crimes, right? Conspiracy, burglary, arson, and all that stuff. Okay, so a conspiracy is what? What is a conspiracy? What is the definition of a conspiracy?
An agreement between two people to an overact to commit a crime.
See, and then you know that I told you that this right here is so important, right? I told my sister there were too many officers at the airport. Okay, that right there, they have an agreement. They do it anyway. You see it? They do it that anyway. So that is the sentence that connect with conspiracy. See it? So conspiracy, there must be an agreement to wanting a crime to be finished, right? Wanting the crime to be finished. And another one that B totally lost is this. And it's very important that your guy have to have this thing in your head, or when you do it with me, you have to say it. A woman at a woman trial, after the government introduced the case of the evidence and it rests. Okay, this is called the case in chief. This is called the case in chief. You see it? That's a case in chief. So that the state rested. After they produced evidence, they rest. And so now the defendant turned to call his or her witnesses, right? So instead of doing that, the lawyer moved for judgment of acquittal on the ground of insufficient evidence. Okay, on the ground of insufficient evidence. Who handled the insufficient grounds of evidence? Who handle that?
The jury.
That's the jury. That's the jury. So, so automatically you should say, oh, no. So therefore, C and D is out. B, analysis got her to the A, but the way she do it would be different than me. You see that? Now, so you can always, while you read this facts, you can always go back and look at C and D. And if your brain say, oh no, it's a jury, it gotta be a no. Right there, you just go to C and D and strike it again. You don't have to do A, B, C, D. You can jump. You can jump, okay? Right? You can eliminate it. So the reason is that they have an agreement, right? They have an agreement because I told my sister there were too many forces at the airport, but then she still take the cocaine to the airport with her sisters. That's conspiracy. You see that? So here's two no. No, because the evidence showed that both the woman and her sister agreed. So you forgot the word agree and you forgot the word conspiracy. The reason why you don't connect agree with conspiracy is because you did not attract the word conspiracy like the light. You guys see that? You guys see that? And it's had to marinate with the fact. See it? And then B, no, because the evidence showed that both the woman and her sister possessed cocaine. Well, conspiracy, not possession. See, because B doesn't circle conspiracy, doesn't play conspiracy in her head, the elements of it. Possess is not an element of conspiracy. Therefore, B is wrong. How cool that is. So whenever you read a crime, you saw a crime, you attract to it, automatically you go over the elements. Okay? The element of conspiracy has nothing to do with possession, right? Got it? So when you possess the cocaine, you are charged with, possession of drugs, but then you're not charged with conspiracy. The answer is
A, correct. A conviction of conspiracy requires proof of an agreement to commit a crime, and in some jurisdictions or under some statutes, proof of an overt act and furtherance of the agreement. The conspiratorial agreement need not be proven through direct evidence, as long as the circumstantial evidence taken in the light most favorable to the prosecution is sufficient to allow a rational jury to find that there was a conspiratorial agreement beyond a reasonable doubt. Here, because a jury rationally could conclude beyond a reasonable doubt from all the circumstances, including the woman's statement about her discussion with her sister, that the woman and her sister had agreed to import cocaine, the issue is for the jury, and the woman is not entitled to a court-ordered acquittal.
in the answer is consists of an agreement, and it consists of the jury. See that, guys? But I take a correct answer any way I can. Right? So today's lessons is a good lessons, is that we are lawyers. We attract to crimes. You got to circle that crime they mentioned up there. You have to circle it and think about the element. So don't skip the crime part, because you might not see other facts that marinate with it. Okay? Anybody have any questions? Anybody? No? Sound good. Okay, I'm now stop live.